Good afternoon. Thanks for joining us today. We are talking about New Jersey discovery, pretrials, trials, and appeals. That's our topic for today. Thanks for joining us. This should be fun this afternoon. We got a large group here today, so please feel free to ask questions. You can type questions into the box, and at the end of the presentation, I've got about 25 slides to work through. I'll leave some time so that I can answer as many of your questions as possible. If you're here live, the goal you should have is to bring some questions to me and have me answer them, and it'll be a lot of fun. I also see some of the attorneys that work here have joined in. I see you, Eric and Alan. How are you? Please don't try to stump me with crazy questions, but maybe do that. Maybe that'll be fun. But if you are here live, please ask a question, type it into the box. I will read your question out loud so the whole group can hear it. I will answer it to the best of my ability. Please leave out any specific identifying remarks about any one of your specific cases or clients, because I want to give general advice, and we are not creating an attorney-client relationship in this webinar. All right, let's dive into today's topic, which again, discovery, what happens in pretrials, what's a trial, and how do we appeal a New Jersey workers' comp case. As we go into this topic, I always want to think about our goal in a workers' comp case in New Jersey. It's to stay in control of that case. We don't want to lose control of our comp case in New Jersey. You have the opportunity to control and direct medical in your New Jersey case. That's the best way you can move that claimant to maximum medical improvement and then move on to the permanent aspect of your case. And we want to make sure we capitalize on that opportunity. We have a lot of ways to learn this topic. Obviously, this monthly webinar, if you're here, is to learn something about this topic. But check out our handbooks. We have them on our website. You can download them. We have podcasts for a month. And one of my partners, Christian, does a podcast called Third Fridays, which is released the third Friday of each month, which is kind of a second level or sort of a 201 level discussion. And he'll bring in guests and discuss sort of topics in workers' compensation law. So if that's something that appeals to you, just like to point that out. All right, today we're going to talk about what kind of discovery we can get under the court rules. I'm going to talk a little bit about the very interesting pretrial process in New Jersey workers' comp cases. I'm going to talk about trial sequencing, and I can just tell you that trial sequencing is one of those things, meaning what order do proofs come into a workers' compensation case in New Jersey is one of those things that we're always talking about here. You know, it sometimes feels like when your case is going to trial, it's this crazy big event and there's so much moving, but really in this context, trials are short and non-continuous, which means it's one witness typically at each hearing or proceeding, and then there's a couple weeks at least in between each proceeding. So trials in this jurisdiction are very tactical and are usually used as leverage towards settlement. So I'm going to talk a little bit about how we leverage the trial sequence into a opportunity moment for us to resolve our cases. And then I'm going to talk very briefly about appeals in this context. All right, let's start with a discussion of discovery. Now, there are specific discovery tools which are allowed by rule. These are in the regulations. The this area of law is governed by the statute, which gives us the Workers' Compensation Act, but also the court rules, which are encapsulated in the Register of Regulations. So we have specific court rules that apply only to workers' comp cases, and they are in the regulations that govern practice before the workers' compensation courts in the state. And that limits us to what we can ask for in a case. So in every case, whether it's accepted or denied, we can issue a demand for medical information to opposing counsel. Opposing counsel then is required to provide us with all medical information in their file, including medicals that do not relate directly to the instant workers' compensation case. And the rule says that if opposing counsel has medicals in their file and they don't provide them to us, and then we have to go and obtain those medicals on our own, that we can actually charge the cost it took us to obtain those medical records to the other side. So that's something we can use to try to compel the production of medical information. Additionally, we can serve interrogatories in some cases. What are interrogatories? They're just written questions, really what you would ask the claimant in a deposition, just in a written format, and the claimant has to give you a response. Now, oftentimes when we issue interrogatories to opposing counsel, they give me back these vague responses, and they say, well, the petitioner claims that they got injured at work, maybe they were exposed to a loud noise, which led to a hearing issue. And we'll say, okay, describe the loud noise. Where did it come from? What was the machine that exposed you to that loud noise? And in response, they'll say, I was exposed at work. You know, really non-specific, very vague. Where the petitioner is not being responsive to our interrogatories, they're answering in a vague way, we can do a motion to compel more specific answers. So this can be a powerful tool for us to obtain information about the petitioner's case in chief. We can also issue a request to the Department of Labor for them to provide us with copies of all prior claims filed by the petitioner in this jurisdiction. So the New Jersey court itself will issue to us copies of that. They'll send literally a physical printed copy to us of all of the prior orders approving settlement and anything that was filed in the workers' compensation courts. We can also use the electronic docketing system to find some of that information, but a prior claims history from the Department of Labor is often, particularly for the older claimant who's had cases in the 80s and 90s, it'll be more complete. In a total disability case, we can also issue a demand for a certification of pre-existing conditions. This is incredibly useful for us in a case where the claimant is likely to make a claim for total residual disability or total industrial disability, and we need to look for opportunities to bring in the second injury fund, which will be a topic that we're going to reach, I think, in 2 months from now. The second injury fund in New Jersey, it's one of the last states that still has a second injury fund that will pay for permanent total disability should the petitioner have a pre-existing condition. So getting a statement of those pre-existing conditions is very useful. There are also some discovery techniques that we can deploy that are outside of the rules. So remember that we can go to the Social Security Claims Center for Medicare and Medicare Services, and we can issue forms that will provide us with either the complete record for their Social Security claims or their earnings history. And so there are very specific forms that we can file to obtain those. Very useful in occupational exposure or repetitive motion cases where we think that there were prior periods of work exposure which contributed to the petitioner's resultant or cumulative disability. In every case, we also issue a Medicare eligibility affidavit to every single claimant. Even though the claim petition form that's been promulgated by the Workers' Compensation Court requires the petitioner to indicate if they are currently Medicare entitled, we ask for a separate affidavit as well. Oftentimes I do that because the original claim petition is not signed by the claimant. It's filed electronically, and I don't have a copy of their signature on that. And again, I already talked about a prior claim search. We can do one through Courts Online. We also ask our clients to perform an ISO or Claims Index Bureau report on the petitioner as well, just to determine if they've had any other claims in any other jurisdictions, because that will not be revealed by our search of the Department of Labor's records. Some additional discovery opportunities as well. We have the opportunity to issue subpoenas in this jurisdiction. They have the same impact as if they were served in a civil court case. And in fact, the court rule, which specifically allows us to issue subpoenas, says that we have to issue those subpoenas in a manner which is consistent with the issuance of subpoenas in a civil matter. We can also do a request for depositions, although this is rarely ever done. Depositions are really not supposed to happen in a New Jersey workers' compensation case unless the claimant or the deponent is about to die. So they are allowed in circumstances where the petitioner is expected to die shortly or long before their case could ever get in front of a judge for the purposes merely of preserving testimony. So again, very rarely granted. In every case, we make a demand for the petitioner to execute HIPAA-compliant medical releases so that we can fully and thoroughly investigate their medical history. Other discovery Devices that we can deploy are a request for independent medical evaluations and functional capacity evaluations. And in this jurisdiction, both IMEs and FCEs can be conducted at any time, simply on notice to the other party to say you need to appear at this date and time. You can do them as often as you want. And unlike other jurisdictions that we practice in, like New York, you can communicate with your independent medical evaluator. You can provide them with medical records, directional letters, etc., to make sure that you get an independent medical evaluation which fits the needs of your specific case and addresses your concerns. What happens when the petitioner doesn't comply with our discovery demands? Well, we can file motions to compel. The petitioner has to provide interrogatory responses within 45 days of the service of our interrogatories. If we do not do a motion to compel or serve discovery within the 180 days from the filing of our answer, our discovery can be deemed closed. What does that mean? It means, yes, you have these discovery opportunities, these disclosure devices. You can serve interrogatories. You can do this stuff. You can request medical information. But if you don't make those requests timely, they can be deemed waived. And that's something really important to be mindful of. And it works two ways. First, I'm always careful when a client refers a case to me to defend that's been already defended by another law firm, so they ask me to substitute in and fix the problems. One of the challenges I might have is a prior defense counsel didn't serve discovery timely or didn't follow up on discovery, right? Because it's not just about serving discovery. You actually have to make sure the other party responds, and you have to review it and say, wait a second, these answers to interrogatories are incomplete. They were vague, they're evasive, they're useless. You didn't answer the questions. You've got to file a motion to compel, right? You've got to do something. And oftentimes when cases get referred to me that somebody else has had their fingers on, they haven't done those things to perfect their discovery methods. It puts us in a bad position, and I'll often have to go to the court and say, Judge, you need to reopen the discovery period because I need to get this information. It will make this case more clear to everyone. It'll bring the facts to the front. That's what we want to do. And Judge, you need to reopen the discovery period. And in general, we've had good luck with the judges saying, okay, that's right, that's fair, we're going to reopen the discovery period. But I also would remark that this discovery period works the other way as well. So where opposing counsel has not conducted discovery within that 180-day period, I'm going to make the argument that they're foreclosed from making that discovery. So many times in a workers' comp case, I make a motion to dismiss during the pendency of the case, and I say, look, you can't prove that you were my employee or that this accident occurred, right? You haven't met your burden. You haven't shown a causal relationship. And opposing counsel come to court and say, well, Judge, that's fine, but we need to look into this, and I need to get these records from the alleged employer, and I do these other things. And I say, well, Judge, the time for discovery is closed. It's only 180 days. And if opposing counsel is not savvy and they don't move to expand or reopen the discovery period, the judge can rule, I'm sorry, the time for discovery is over, and I'm going to grant the defendant's motion here, the respondent's motion, right? So we've got to be prepared to both follow up on discovery demands that we make, and otherwise we're waiving them, and we can use this to protect ourselves from maybe unnecessary disclosures, and particularly in the dismissal context, where opposing counsel is going to try to do anything they can to avoid their case from being dismissed. So that's how we use discovery to set the case up for pretrials. What is a pretrial? A pretrial just means a conference with the judge of compensation, right? Now, technically, at the result of every pretrial conference with the judge of compensation, a pretrial memorandum should be issued. That's what the courts envisioned, or the legislature envisioned in 1979 when they created the statute and regulations. However, the result of most pretrial conferences is just a bunch of conversations and usually an adjournment, right? And this is one of the chief frustrations for my clients in a New Jersey workers' compensation case. They go, Greg, you go to 100 hearings and nothing happens, right? And the answer is because the pretrial process has turned into essentially a case status conference. They're called pretrial conferences, but really the way the judges approach them is as a case status conference. And what the judge will say is, hey, are you ready, respondent? Are you ready, petitioner? Oh, somebody's missing something? Okay, I'll give you a giant adjournment for 6 months and you'll come back and we'll look at the case again, right? At that moment, instead of the judge issuing an order or a pretrial memorandum, usually the judge says, okay, informally, I'm just going to adjourn this case. Again, very frustrating for our clients. It's something that's outside of my control because the judges have control about what happens in a pretrial conference. But in a pretrial conference, the judge is supposed to narrow and limit the issues in dispute and get to the heart of a case. Now, New Jersey also has this unique idea of hearing cycles, which is that the courts work on a 21-day hearing cycle. And they've even gone and identified the hearing cycle that every case falls on. What this also means is when you're a defense counsel, like I am, you get a very specific day listed in all the courthouses that you go to, because all of my clients' cases will be listed on that day. It means when I adjourn a case, I have very good predictive power as to when that case is going to come back on the cycle. That's important, right? Because part of what we're doing as defense counsel is trying to get these cases moving. We're trying to move them forward. I'm there generally saying, Judge, let's address this today. Let's get a pretrial memorandum. Let's put this on the trial calendar, or let's settle the case. Let's do one of these things. Opposing counsel often, because again, they're juggling hundreds of cases. We're not juggling anywhere near that number as defense counsel. They're often just pushing these things off and trying to adjourn them. Here's where we're going to try to manage our docket, manage our docketing system, so that we can try to get these cases moved back quickly before a court so we can get some action. The court publishes its own date calculator. Here's an old example of one of them that predicts when each case will be adjourned to or relisted. So this, again, is useful for the main purpose of predictability, right? Again, when I'm thinking about my docket, I'm thinking about when is this case going to next come on? What can we accomplish between now and then, and how can I get some traction in my case? Very predictable system. It also means that because the judges have so much flexibility in their calendar, they can do what we call add-ons. If you settle a case in between hearings, you can ask the judge, you can call up the judge and say, hey, Judge, could you add this one on for a settlement? Nearly all the courts are virtual now, and they will do a settlement almost instantly. Okay, very useful. Again, if you reach a resolution outside of the presence of the judge, both parties agree, we can generally get back in front of a judge instantly, really quickly. Most judges are really accommodating about giving us time on their calendar. We can go in the afternoon. Some judges will just simply approve settlements on the papers. They'll ask for the petitioner to execute an affidavit, and they will push it through quickly. So in this jurisdiction, although not much happens at those pretrial conferences, and again, they're treated like case status conferences, but if you do reach a settlement, you don't have to wait for the court to list it. You can contact a judge and we can get it on that calendar, usually the next day, right? So very quickly. So that's actually useful for us, and it instructs how our practice works. Next, you can present testimony virtually, including doctors. And this is a great time and expense saver. Now, nearly all the courts have gone virtual, although there are still a couple that want the attorneys to come in person. Off the top of my head, I think it's Hackensack and it's Mount Arlington. Those are 2 out of the 15 hearing points that require in-person attendance by the attorneys. Unfortunately, that brings with it some time and expense, which we can't control. But most of the courts have gone completely virtual and are holding courts over Zoom or Teams or GoToMeeting or WebEx or something. And the reason I say or something is because there is no one standard. Every single court, or every single judge seems to be adopting their own standard. One judge likes Ring Central, one judge likes WebEx, one likes Teams, one judge just sends out meeting invites, some use a phone call. So it is really judge by judge, courtroom by courtroom, whether or not the matters are proceeding virtually or not. Now, our best practice here is that 2 weeks before any listing in court, the paralegal is preparing the case and will send a preparatory email to our client. 1 week before the listing, the attorney is going to review the case and make sure that the client has an updated conversation with us. And within 24 hours of every hearing, we are going to send you a post-hearing report. Our goal, of course, when we attend to a pretrial conference is to have an outcome, something happened. And then we want to quickly report to you what happened, what was the outcome, what was the result, what was the traction we got, what's the leverage we created, what are the next actions in this case. And I want it to be simple and concrete, plain English, shouldn't be tricky, so that we can get on the same page and move forward and try to resolve this case. All right. Pretrial conferences. Now, a case, unfortunately, will typically be listed for many, many, many pretrial conferences. It's not uncommon for a case to have 15 pretrial conferences. And again, these are just status conferences with the judge. These are simply conferences. We're supposed to be identifying outstanding discovery and discussing any issues. And in the old days, this used to be where we would settle most cases. And the reason we would settle most cases at that time is because all the parties were there, right? We were in person before COVID. Everyone would be there. Respondents' counsel would be there. Petitioners' counsel would be there. We would talk about the case informally. We'd settle a lot of cases on the courthouse steps. Nowadays, that's less common. Nowadays, we're settling cases mainly over the phone, in between hearings, in between listings. That's where we are going to do 99% of our work in this jurisdiction. Now, a pretrial conference can result in a simple adjournment or a discussion between the parties, but the only formal result can be a pretrial memorandum. And this is an important thing to note. A pretrial memorandum is literally an order that is setting the case down for a trial. You'll hear experienced practitioners, people like me who've done this for 20 years, call it the green sheet, because this pretrial memorandum used to be present in every courthouse. Used to be a pile of them, and they were on green carbon paper and green pieces of paper, so that you would know when you walked out of courthouse with a green piece of paper, okay, my case is now going to be listed for a trial proceeding. And that really meant something. It meant the case is now going to, next time you come to court, be prepared. There's going to be witnesses. The petitioner is going to testify. We'll talk about the order of proofs in a second. Now, the pretrial conference requires specific disclosures on that document. We have to list everything that we're stipulating to, and see, and this image that you're seeing right now is a scan of a pretrial memorandum. You'll notice it's not green, it's now white. And the reason for that is no one's using the carbon paper anymore. We're using just a regular piece of paper, but we're supposed to list all of our stipulations, which is everything that we can admit or accept in a case. And again, the point of the pretrial memorandum is to narrow or limit issues in dispute. We have to list all our witnesses. And I think the best practice is to list even potential witnesses, meaning witnesses that I might bring in only for rebuttal purposes. The judge has a requirement. They have to sign the pretrial memorandum, and at the bottom right-hand corner, it says recommendation. So where the issue is how much, how much compensation is the petitioner due? How disabled are they? The judge should be writing down their recommendation. So if you don't trust your defense counsel, you don't think they're doing a good job for you, and they say, I'm going to go to court and I'm going to pre-try this case before the judge of compensation, and you want to check their work, say, hey, send me a copy of the pretrial memorandum. What did the judge write down? Because my experience has been typically when the judge spends the time to sit there with counsel, review the medicals, review the status of the case, and give their opinion as to what they're going to rule after the trial, that's a really good indicator of what they're going to actually do, right? So you're going to get a good written opinion from the judge on that pretrial memorandum. So take a look at that. That's a really useful thing. On our best practices are on every green sheet that we add a specific sentence. It says, quote, the respondent reserves the right to provide testimony or documentary evidence to refute the claims of the petitioner and or establish the commission of fraud as defined by the fraud statute, and specifically reserves the right to obtain and or produce such evidence after the petitioner testifies as per Gross versus Neptune, okay? We always put that on every green sheet. Now, this always sends up a red flag to opposing counsel. They say, wait a second, why'd you write that on there, Greg? Do you have video evidence of my petitioner? What are you saying here? And often I'll have to tell them, like, well, I don't have to reveal if I have video evidence. I'm reserving my right to present it, but I may. That's what I say, right? Because that puts them on notice. If you don't reserve your right to obtain surveillance video after the petitioner testifies, you may have waived that right. And there's case law that says that. And that's why I include it in all of my pretrial memorandums. Again, I think this is best practice. Now, if you do have surveillance video, you do have witness testimony that's going to directly refute the petitioner's testimony, you need to be prepared with that. And I think best practice is to identify and list the witnesses that you're going to bring forward. That will prevent you from being precluded of presenting those witnesses. Savvy counsel, if you try to present them, we'll say, wait a second, you didn't put that down on the pretrial memorandum. that witness is not coming into the case. And that, I think, would be a good argument that they could make. So we want to be very careful and avoid that. On every green sheet, I always add additional employer witnesses without naming them. I say to be determined employer witness, at least 2. And I also reserve unlimited trial time for me and my client because I want to have the opportunity to present as many rebuttal witnesses as is necessary to demonstrate all of our proofs to the court. All right, so now you've completed your green sheet and you're ready for trial. Let's talk a little bit about the sequence of trial, because the sequence of trial is set forward in the court rules. The trial of a workers' compensation case in New Jersey should follow a very strict and specific order, and more than 90% of them do. Oftentimes, when the only issue in dispute maybe is a limited issue. For example, the only issue in dispute is an issue of medical causation. Petitioner's counsel say, can we just put the doctors on? Can we skip the petitioner's testimony and respondent's testimony? And there might be a good strategy reason why you want to do that. Maybe you're just trying to reduce costs. Maybe you're trying to be more efficient. Maybe bifurcating on that issue makes sense. So 10% of the cases will do that, but about 90% of the cases should follow the typical trial sequence. And here is your typical trial sequence. And I've created this little chart here because I want us to think about not just the trial segment or the sequence of trial, but also what about our decisions and how much is this costing us, okay? So every trial begins with the petitioner testifying. That is set forth in the rule which governs trial testimony before the workers' compensation judge. Okay, relatively quick and easy to schedule the petitioner to testify, right? Again, we're doing this over Zoom, so this should be done relatively quickly. Cost is nothing, right? Very cheap. The only cost that's going to be incurred associated with the petitioner testifying is really just the cost of the court reporter who's going to transcribe or create the stenographic record of their testimony. So it's really, really cheap and quick. Now, this is where most trials settle or resolve, right? The petitioner makes outlandish claims. We're refuting them. Maybe we have medical experts who have, contradicted the petitioner's claims. They say, oh, they're malingering or they're exaggerating or these claims are unrelated. Well, after the petitioner testifies, the judges had an opportunity to see the petitioner, we've asked our cross-examination questions, right? Hopefully they were well prepared and they boxed the petitioner in and created a really good boundary or tested their credibility or contradicted themselves, right? So we did something useful. We got some concessions from the petitioner so that we did our job, essentially, as defense counsel. And after the petitioner testifies, the judge says, all right, well, I thought the case was worth X, but after the petitioner testifies, now I'm seeing this. Great. Opportunity there. Opportunity for settlement, right? Quick, cheap, easy. We should not be afraid of taking petitioner's testimony. Pretty quick, pretty cheap. Next, in the regular order of proof, so now I'm looking again at trial segment. Next, the employer witnesses testify or any rebuttal witnesses. Again, pretty quick. Usually I'm producing their manager or I'm producing a surveillance operative or someone who can directly refute their claims. Again, pretty quick, pretty cheap, pretty fast. So usually within a few weeks. And again, remember, these trials are non-sequential, which means you don't start a trial on Monday and continue on Tuesday, Wednesday, Thursday. The petitioner will testify in a case and then the judge will adjourn it, usually a minimum of 21 days before the next testificant testifies. So you've got a lot of time between their testimony to try to resolve issues, narrow issues, and maybe settle the case. All right, so the second step is the employer witnesses testify. And then the third step is the petitioner has to bring in their IME doctor. This usually takes a long time for them to schedule because these petitioners' IME doctors are professional witnesses. They're examining 50 claimants a day. They're testifying in lots of cases. Usually takes a couple months to get them onto the stand, okay? It's usually quite slow. Cost is not very costly. In fact, it's limited by the statute as to how much this can cost. But this is where the case starts to slow down. And again, that just means that's a settlement opportunity for everybody. After their IME doctor, we can then put on their treating doctor. The order of proofs allows this, and I love to do this because who was the treating doctor? It's who I sent them to. Usually a more conservative physician, usually a results-oriented physician, and because they're the treating doctor, they're the doctor that's going to come on and say, yeah, I healed them. I did a good job. I did my job as a doctor. They're fine. What are we doing here, right? Oftentimes, both opposing counsel and the judge will resist putting the treating physician on the stand. They'll say, oh, Mr. Lois, it's going to take too long. We don't need to do it. We have experts. Well, why would we refuse to put the treating physician on the stand? And the only reason really is cost to us. It is going to be very costly to put them on the stand because this is a treating physician who's going to be called out of their normal practice, and they're going to have to spend a couple hours, perhaps, on a phone call with the judge or on a video Zoom. If we do not present the treating physician, the next person to testify is usually our doctors, our independent medical experts. This can be very costly. I've got one unfortunate medical expert, writes great reports, but is charging $5,500 for 2 hours of testimony. That's a lot of money to testify in a workers' comp case. So we try to use that sparingly, right? Writes a great report, does a great job, testifies real well, but that's really expensive. Somewhere between $2,500 and about $5,000 seems to be about the norm. Beyond that, it's a little ridiculous for an hour or two of testimony. It really usually goes in quite straightforward. But again, they can testify over video, so that should reduce some of the scheduling conflicts. But again, very slow. We're now 6 months after the trial has started by the time all of these witnesses have testified and been brought into the case. Lots of opportunity there to resolve your case, but maybe you couldn't. Maybe after all of that, the judge makes a decision, and the decision, you don't like it. Well, then you can appeal. And you can appeal a lot of things in this jurisdiction. You can appeal any final decision. That includes any order of the court, and that includes any order of the court for a motion for medical and temporary disability benefits. I have successfully appealed motions for med and temp, particularly motions for med and temp that decide something jurisdictional, like first established that it was my employee and then ordered me to pay or do something. Now you've got a jurisdictional appeal. Really, that issue of employment or not my employee should have been decided first. We made great case law on that a couple of years ago called Calix versus Utica, great decision. So almost anything can be appealed if you're careful about it, but you can't appeal any order that you consent to, right? And oftentimes when an issue has been resolved, the judge will say, hey, can everybody sign a consent order? Be careful about that. Judge, you can enter an order and I can read the order, but I'm not signing it or consenting to it. In order to be successful in an appeal before the New Jersey Appellate Division, the briefing rules require that we have to raise specific objections in the trial court for every single appeal point that we're going to raise in our appeal brief. I actually have to specifically cite to it in the page and record. And so we have to be very careful as the trial is continuing to object or raise exceptions, particularly to any sort of fact findings or usually it's evidentiary issues, what can come in, what should come out, what's hearsay, what's not hearsay. Very recently, we just got an appellate decision 2 months ago in a case called Bello versus United Pan Am. And the issue in that was the scientific standard of proof in a workers' compensation case. And I put that out in our newsletter a few months ago. Again, we have to specifically object and raise those issues at the trial court level in order to preserve them for our appeal later in the case. Last thing I'm going to mention when we talk about appeal in the New Jersey workers' compensation context is statistically only about 1 or 2% of cases get appealed. It's actually very rare to have an appeal in this context. And of the cases that are appealed, very vanishingly small percentage are those appeals. Does the defendant get a reversal, or does the petitioner get what they're looking for? Probably less than 10% of the time do those appeals result in any kind of meaningful reversal. In fact, in this jurisdiction, it's not uncommon for a year to go by with only 1 or 2 significant appeals being filed in the entire year, and that's out of 35,000 plus cases filed every year in the workers' compensation jurisdiction. Okay, so just this appeal should be used sparingly. Now, in the last couple of years, LOIS Law Firm's won a bunch of great appeals, but again, we're very out there in terms of aggressively defending and pushing our cases. That's a very out-of-band result that we've been obtaining. What kind of things can we appeal? Can you appeal a Section 20 order? No. Can you appeal an order approving settlement? No, because you're consenting to those things. You're agreeing to those things, okay? A judicial order, yes, can be appealed. Now, some other questions I get are about reopeners. Remember, this is a jurisdiction that loves reopeners. Be mindful that any case that closes by way of a Section 22 settlement, that's an order approving settlement, can be reopened. And any order of a judge after a trial, the judge finds a degree of permanent residual disability, be mindful that is subject to reopener. Most reopeners, though, over 95% of them, we're going to close by way of a Section 20 settlement once they've been reopened. Appeal strategy in this case, in this state, is also unique. There's no automatic stay for any issues that you're appealing. The average time to appeal is about 18 months, which means appeals have little to no tactical value in litigating your underlying case. In other words, if you're filing an appeal in this jurisdiction, you should plan on trying to win that appeal. You strategically need to win that appeal because the pendency of the appeal in the appellate division is not slowing down your workers' comp case. The judge is not going to have to be bound by it, and typically no issues are going to be stayed pending appeal. So think about them from a strategic impact perspective. Also consider the potential for creating a negative precedent. Right now, we are desperately trying to create precedent, particularly surrounding medical provider claims in this jurisdiction, and I am creating fights and filing motions and moving for dismissal and medical provider claims because I want opposing counsel to appeal me so that we can go up to the appellate division and I can create great case law. But there's also a downside. Be mindful, be thoughtful when you appeal in this jurisdiction because there is a potential to broaden or perhaps worsen the workers' compensation application of law for all employers in the entire state. So be mindful that your appeal can result in a published decision which will have a broad impact on other cases. All right, some takeaways before we get into questions. New Jersey does allow for very extensive discovery. Absolutely use it. I think most of our job as defense counsel should be done well in advance of the pretrial conference. If you are expecting to go to the pretrial conference and have some meaningful movement in your case, that is not a good strategy. The tactics that are successful here are working the case before it gets to the judge and positioning your case for success. Clients should be very well informed about what's going to happen at those pretrial conferences. These are not pig in a poke. These are not, it's not open season, and we should be very mindful. The judge is very limited in what the judge can do in a pretrial conference. They're there to narrow the issues in dispute and try to resolve issues. This should be an opportunity for us to confer with opposing counsel and try to come to some sort of resolution of these cases. Trials, when you have to undertake a trial, and I think trials unfortunately are underutilized in this jurisdiction, but trials are non-continuous and they are your opportunity to settle. Last takeaway is that appeals are extremely rare and very slow, so be very thoughtful. You want to have a winning strategy on that appeal. Do not do them for tactical purposes. All right, let's move into questions. I'm hoping there's some good questions today. All right, Miguel asked a question. Greg, if appeals are incredibly rare, when would it be appropriate to appeal an order? And what's the typical success of these? All right, so great question from Miguel L. If appeals are incredibly rare, when should we do them? Well, the answer is you should appeal when A, an order or decision is coming out that's going to really prejudice your ability to resolve or settle that case. B, when the judge has misapplied the law to your case, the appellate division will not be deferential to the workers' compensation judge where they have incorrectly applied the law. And if you look at the appellate decisions that I've obtained in the last 10 years, those are cases in which the judge was typically confronted with an edge case where they applied the law incorrectly. One of the most meaningful decisions I obtained was Calix versus Utica, in which the judge of compensation, in a disputed employer context, made an order of medical benefits and just arbitrarily said, well, this employer is going to pay for the medical, but if it turns out later that you're not the employer, this other person's going to pay. And we made an argument. We said, well, look, as a matter of law, that's inappropriate. You can't just say, well, all of you guys are guilty and we'll just figure out who's guiltiest later. the judge has to reach that threshold decision of who is the correct employer first. You can't punt on those jurisdictional issues. The appellate division agreed with us. And again, that's very good case law for us going forward in the disputed coverage or successive coverage environment, right? When you see those cases again, now we've got great case law on that. So you got to be thinking and picking out the case where the decision the judge made as a matter of law was inappropriate. Oftentimes, this will come with the application of evidence or a party disputing whether evidence should be allowed in or precluded, whether it was hearsay and how much weight it was given. Again, those are ripe issues for appeal. So again, Miguel's question is, what kind of cases should you appeal? And unfortunately, the answer is, it is very case by case. I can tell you when you should never appeal, and that's when it's simply a tactical appeal. You just didn't, there's some minor issue in the case that you want to correct, but it's not going to actually win your case. Because again, your workers' comp case will be proceeding, and you're going to get to a final order anyway, and maybe that's when you should have taken the appeal. So think strategically when you file appeals in this jurisdiction. All right, let me check again, see if there's any more questions. Well, that was it. Thank you for asking that question, Miguel. Again, it makes it a lot more fun. All right, guys, thank you for attending today. I hope this was useful for everyone and we learned something. Next month, we'll have a new topic, so I look forward to meeting everybody again next month. Have a great rest of your week.